Mr. Njiro has the habit of taking over courts. I'm glad this court has not allowed it. But Your Honor, there's a new issue that has been raised about...
Yes. Your Honor, you know that's a very serious allegation that it is...
Can I place this, just a moment, counsels, can I place this aside and serve the common Mwananchi who is waiting for me?
Yes.
And then maybe we record a consent on the way forward. Is it possible? Because if we do this back and forth like this, it's going to take long. There are people here who need to know what is cash bail, what is the fine, if any, so that they start looking for it to pay before they're taken to the remand.
And I'll stick to the 3 minutes and we'll be done. I just wanted to raise with the court that Mr. Okach has raised a new issue on Article 25, which was not there, about torture. And if you allow me, in addition to answering to the question as to whether Mr. Tuju is in custody, allow me to start with the response to Article 25.
Okay.
You've been told a lot of factual matrix. I mentioned it earlier. None of them on an affidavit. I do not have any reason to doubt the Vice President, the former Vice President of Kenya. And I repeat that we sympathize as the prosecution from the factual narration. However, there is no evidence, which can only by way of an affidavit, to the extent that there has been torture or inhuman and degrading treatment, which then would invoke Article 25. Before that affidavit fits on your desk, this court cannot be persuaded by allegations of torture and inhuman and degrading treatment. I thank you on that point. Is Honorable Tuju in custody of the police? Yes. The OB number is OB 31/23/3/2026.
Let's take that again. OB number?
Sorry, let me just get it again. OB number 31 /23 /3/2026. Even in hospital, he is in the custody of the police. It is the prosecution's position that even pending appearance, he will remain in the custody of the police until and unless we are back to this court earlier, if that is possible, or the police in their own discretion, which the Director of Public Prosecutions cannot get into, consider a grant of police bail.
Prosecution.
Thank you very much, Your Honor. I am sure Mr. Njero will not need to deal with me. We'll go very straight to the point. Your Honor, the jurisdiction of this court has been questioned. Let me address that at the preliminary level. You are told that this court lacks jurisdiction by an absence of an accused person. That's legally misleading and inaccurate. Now, in the CAK authority, which I believe is known to all of us, the jurisdiction of a court is granted by the Constitution or the law. It is not granted by the presence or absence of an accused person. This court is characterized as a subordinate court by the Constitution of Kenya, and the jurisdiction of subordinate courts is granted by Article 169 of the Constitution. And then that particular article of the Constitution is given effect to by the statute called the Magistrates Courts Act 2015. In addition to Article 169 and giving effect thereto, the criminal jurisdiction of this court is granted by Section 6 of the Magistrates Courts Act. To be more particular, as regards offenses under the Penal Code, Section 6, subsection A of the Magistrates Courts Act 2015, so that this court has jurisdiction, whether or not an accused person is present. One of the innovations of the new constitution is that even in the absence of an accused person, although the circumstances are important, where it is impossible, or rather it is impossible to proceed with proceedings in the presence of an accused person, then a
Presence or absence?
sorry, in the absence. Thank you,
Yes.
Mr. Ndegwa.
Yes.
Thank you.
No, he will not mislead me. It's okay.
Not I will not, I cannot.
Okay.
I
Yes.
cannot mislead the court.
Yes.
That one of the innovative inclusions of the new constitution is that a case can proceed even to conviction in the absence of an accused person.
Mr. Oruko, as an advocate, what are you doing? Are you an accredited journalist or media person? Is that proper what you're doing? As an officer of this court, you know the rules. Is that proper? This is not just for your gutter press or anything. What did I say earlier? Mr. Oruko, you're an advocate. What did I say earlier? You didn't hear? You know what you're doing, right? Stop it. All right. Yes, go ahead.
Thank you, Anna.
Yes.
So that we respond that the absence of the suspect before you does not take away the jurisdiction of this court to consider the matter before you. Having said that, Your Honor, we sympathize with the factual matrix given by the Honorable former VP as regards the circumstances surrounding the arrest, which otherwise they characterize as an abduction of the suspect. However, Your Honor, as confirmed by the Defense Counsel, Honorable Tuju is at Karen Hospital as we speak, having been taken there by police officers from the Karen police station. The right thing to do this morning than to drag a sick man to hospital, to court, the police officers took him to the Karen hospital. It is confirmed by the defense. We wish Honorable Tuju a very quick recovery.
Yes.
A suggestion has been made without basis, with a lot of respect, without basis, that the charge sheet before you is defective. An interesting argument is made that the charges are in personam as opposed to being in rem. We agree that the charges are in personam. Questioning the defect in the charges cannot happen in the absence of the accused person. While the court cannot lack jurisdiction in the absence of an accused, the viability of the charges cannot be questioned in the absence of an accused person. Interesting twist, I know. The question as to the defect or viability of the charges can only happen in the presence of the suspect. As regards the charge sheet, you've also been told, which ties to the question of jurisdiction, that in the absence of an accused or a suspect, we do not have charges because the validity of charges depends on the presence of an accused. False. False. The validity of charges is based on the Criminal Procedure Code, Chapter 75 of the laws of Kenya. And it says that a charge shall be sufficient if it has a statement of the offense and particulars sufficient enough to respond thereto. I must be talking about Section 216, Your Honor. I may need to confirm that a charge shall be viable if it has a statement of the offense and it has particulars sufficient to answer thereto. But as we have said, without the accused person, whether or not the statement and the particulars are sufficient cannot be a question to be addressed in his absence, because the charges are as against the accused person and not his advocates. The final point we address is whether or not this court can grant what I think my learned friend has called bail pending appeal in error.
No, correct.
Oh, it was corrected. Oh, it was corrected. I'm sorry, it was corrected, Your Honor.
Bail charge pending.
One
Bail pending
person
charge.
can tell him. We don't need to all tell him.
They are my friends, I agree.
No, but one can tell you for order,
It
good
is very
order.
obvious for Mr. Owiti to make such kind of technical misrepresentations. Deliberate.
I withdraw that bit. It was not a misrepresentation.
Deleted.
Your Honor, that the accused person in his absence be granted bail. Your Honor, we are opposed to the grant of bail in the absence of the accused person. We already, however, had alerted our colleagues that we were not going to oppose bail upon charges. Why, Your Honor? Because the court has been informed that the suspect has been hospitalized and a factual matrix has been given about certain injuries. My colleagues have not used the word violation, but that's what I suspect they were indicating to the court. This court needs to see the suspect, assess his condition as soon as he's able to get back on his feet and is able to understand the proceedings, make appropriate orders, including an order pursuant to Article 49(1)(h), which is an order for bail. We therefore, in the alternative, propose that it is in the interest of all, or rather both sides, both the defense and the prosecution, that Honorable Tuju gets treatment as a matter of urgency, and that in our alternative proposal, as soon as he is back on his feet, appears before this court, the parties to address the viability of the charges. If we agreed on their viability, he proceeds to take plea, then the court can grant reasonable bond terms as is in the words of the Constitution. We therefore agree with the proposal by my friend, my learned senior, Mr. Oonge, that for today, these proceedings are to be deferred until the subject thereof is able to understand the proceedings. We then shall come back as to the question of plea and bail bond. You know, with reservation to my colleagues, if they have anything else to add, and subject to the court's questions to me, I'm glad to appear before you today. Thank you.
You're welcome. I just want to find out, when defense was submitting, somebody talked about 2 weeks. Was it you, Mr. Njiro? Or it's you, yes. So he says until that happens, prosecution, are you in agreement? No, it's okay, Mr. Onge. I just want clarity from the prosecution as to whether they are in agreement with the 2 weeks or not.
Well, I've confirmed. Can we take 1 week? My seniors proposed that we mention the matter in 1 week. Mr. Tuju does not have to come in that 1 week if he shall not be in good health.
So 1 week for
Yes.
update.
Yes, we could also
1
be
week for
1 week for the
what?
mention,
For mention for what purpose?
to confirm the status of his health. If he shall be
For
fine, we have our
update.
touch sheet ready.
For update on his health status.
Yes. We also humbly request that a medical report to that effect is availed to court.
At that time.
Yes. I'm most grateful.
Just a small clarification with this commission of my senior counsel,
Yeah.
Mr. Onge, please, I said my proceedings must be they must make sense, even to whoever is reading after this.
Okay.
Let us give the prosecution time. I'll give you a very brief moment for rejoinder. Is that okay? Because it's the defense that went first. So prosecution, you have all the time. My prosecutor, Marianne, you have all the time to add on to what Mr. Owiti has said. Not all the time, as it were, but a chance to do that quickly. I have other members of the public in court who are waiting to be served.